ZTV, etc. While ZTV, etc., they were showing as if, everything is a bliss in state of UP in the reign of CM Yogi ji. So I found that it was very biased. Also, ma'am, I also found that media ownership plays a very important role in the type of content media serves to the public. So ultimately, public has this bias before even elections are announced, election results are announced, before even they cast their votes. They have this apprehension, they have this impression in their mind that this particular candidate is good for us and this is not. And it is all because media is the fourth pillar of democracy, and it has a very profound impact on the minds of public. So these were my brief conclusions. And also I would like to add that we don't have media laws in India. So there is a imperative need.
We don't have media laws in India at all.
We don't have, ma'am. We have only policies in place which are, like toothless tiger. And then ultimately we are dependent on Article 19(1)(a) of Constitution. We don't have any substantial law or statute in India regarding media laws.
Okay. So आपने आपका ये जो research था, how it is related to the fundamental right of the citizen of India?
Yes, ma'am. So there are two fundamental rights which are in conflict. One is Article 19(1)(a) from the side of media, that they have the right to tell, and that they have the right of freedom of speech and expression. And secondly, it is the right to information or right to know from the sides of citizens. So they have the right to know the truth. They have the right to know information as such, and not information as manipulated and served on the palate by the media.
Okay. Is there any case law? कोई आपको ऐसा case law पता है? कभी ऐसा हिस्ट्री में पीछे ऐसा इतिहास में हुआ था जहां पर किसी लीडर ने, किसी गवर्नमेंट ने, किसी पॉलिटिशियन ने इस तरह के रिस्ट्रिक्शंस लगाने चाहे हों न्यूज़पेपर पर, न्यूज़ चैनल्स पर? कोई केस लॉ ऐसा, कोई ऐसी पॉलिसी पता है आपको? न्यूज़ प्रिंट पॉलिसी ऐसा कुछ पता है आपको? This is also related to the right of media.
Yes, ma'am. Though my research was limited to electronic and digital media, but while I was researching for it, I came across three case laws which were related to print media, like Indian Express case and Bell and Coleman case and Shuffle paper case. So in all these, there was an attempt by the government to contain the content and circulation of the newspaper by imposition of cost and tax. So ultimately, news is an area wherein it cannot be tax-free, but you cannot impose such heavily taxes so that it contains the circulation and content, which will ultimately impact.
अच्छा, ये मुझे एक चीज और बताइए, क्योंकि आपका टॉपिक मीडिया से रिलेटेड है. आप लोग आजकल देख रहे होंगे कि देयर आर सो मेनी केसेस जिनका मीडिया ट्रायल हो जाता है पहले ही. Up to what extent it is right and up to what extent it should be restricted? And is there any case law? Is there any guideline of Honorable Supreme Court जहां पर उन्होंने मीडिया को उनके इस राइट के बारे में कहा हो, your right is not absolute, is not unlimited, rather it's qualified?
Yes, ma'am. So, ma'am, the right to tell which media has under Article 19(1)(a), it's absolutely qualified. It's not absolute. And also, as regarding media trial, it is usurping the function of judiciary. So this is, in my humble opinion, it should not be allowed. And Supreme Court has heavily come down on media houses time and again, though it has not given any particular policy guideline, legislated by the parliament. But then it has time and again suggested that media should not usurp its power. Media has media's function is to just tell the information. Media's function is not to adjudicate on the merits of the
case law. अभी हाल फिलहाल सुप्रीम कोर्ट ने काफी फटकार लगाई मीडिया की.
Ma'am, I can just recall few instances wherein media trial has taken place, but I am unable to recall exact judgment. So, like in the case of Aryan Khan drug case, excessive sensationalism took place. Then Siddiqui Kappan case, he has got bail after 2 years.
सुशांत सिंह केस जहां पर सुप्रीम कोर्ट ने काफी फटकार लगाई. ठीक है, वेरी गुड. खैर, अब ये बताइए, यहाँ पर आपके जो भी सब्जेक्ट्स थे, आई थिंक आपने पढ़े ही होंगे. ठीक, आपका कोई ऐसा है फेवरेट सब्जेक्ट है आपका कोई?
Ma'am, I have done a generalized study across all the subjects, but I find interest in administrative law because it was
administrative law.
Yes, ma'am.
Okay, ठीक है. Administrative law किसी law की branch मानी जाती है क्या?
Ma'am, it's a law belonging to public law regime. So it is a form, it is a species of public law. So, and in public law also we say that it has characteristics which are matching with constitutional law. So constitutional law is a genre and this is the species. So
okay, ठीक है. तो आपको एडमिनिस्ट्रेटिव लॉ पसंद है। आप मुझे बताइए कि ट्रिब्यूनल्स, व्हाट वाज द नीड टू इंट्रोड्यूस ट्रिब्यूनल सिस्टम इन इंडिया एंड वेदर द ट्रिब्यूनल सिस्टम इज सक्सेसफुल एट प्रेजेंट और नॉट। क्या हम जिस ऑब्जेक्ट के साथ हमने ट्रिब्यूनल सिस्टम स्टार्ट किए थे और एट प्रेजेंट जो सिनेरियो है, क्या वो सक्सेसफुल है या नहीं है?
Yes, ma'am. So, ma'am, tribunal system was introduced in India to reduce the heavy workload on the high courts and the supreme and the allied courts. So, ma'am, also there was a need felt that there should be specialized courts dealing in specialized matters. So, when a bench is sitting in the high court, necessarily it does not mean that they would be having technical knowledge as well. So, therein this need was felt that some sort of specialized experts should also sit, and secondly, to reduce the workload of the high court, tribunals were an effective mechanism to to provide an alternative remedy. And with this, 323A and 323B in the constitution was added, and thereby tribunal system was introduced. Later in Ma'am L. Chandra Kumar case, it was held that the judicial review power cannot be taken. Tribunal can act as a supplement, but it cannot supplant. So it cannot exactly take place of the high court. It can only add to the value of high court. So ultimately, they are not equivalent to high court. They are just assisting the high court. And judicial review of high court and supreme court under article 226 and 32.
क्या ट्रिब्यूनल सिस्टम से कोई जजमेंट होता है तो क्या उनके अगेंस्ट हम अपील रिव्यू कुछ है आपके पास रेमेडी?
Yes, ma'am. Appeal lies to the high court.
ठीक है, चलिए तो ठीक है। एडमिनिस्ट्रेटिव लॉ आपका फेवरेट है, और इसके अलावा सिविल प्रोसीजर कोड तो पढ़ा होगा आपने?
Yes, ma'am.
उसके बारे में क्या हाल है? क्वेश्चन पूछे उससे?
Yes, ma'am.
ठीक है, तो पहले ये बताइए, इंजंक्शन के बारे में आपने सुना है?
Yes, ma'am.
क्या बोलते हैं इंजंक्शन को हिंदी में?
I'm sorry, ma'am. I'm unable to recall it right.
अच्छा ये बताइए, आप गुजरात में जो सिविल जज रहेंगी तो किस लैंग्वेज में काम होगा?
Ma'am, of course, it will be in Gujarati, in the lower court.
तो आप इंजंक्शन को गुजराती में लिख सकती हैं?
Ma'am, definitely I can write, but I am unable to recall the exact verbatim which is used. But if I am given the word, I will be able to write it.
You can read?
Yes, ma'am, I can read.
ठीक है, चलिए क्या है ये इंजंक्शन, और इंजंक्शन का दूसरा नाम क्या होता है, किस नाम से और जाना जाता है इसे?
Yes, ma'am. So, ma'am, Order 39 in CPC provides for temporary injunction, and if we want to go for perpetual and mandatory injunction, then we can go in SRA Act. Injunction basically means stay. Until the suit is decided, the stay which is granted by the court to maintain the status quo, that is called temporary injunction. So Order 39 Rule 1 provides 3 situations wherein temporary injunction can be granted. And Rule 2A provides wherein the injunction is breached, there can be a 3-month civil prison can be given.
ठीक है, वो सब छोड़िए, आप ये बताइए एज अ जज अगर आपके सामने कोई इंजंक्शन ऑर्डर रहता है, आपको करना है, तो इज देयर एनी गाइडलाइन रिगार्डिंग द इशू ऑफ इंजंक्शन ऑर्डर? कुछ है आपके पास गाइडलाइन की these are the factors which should be considered before granting the injunction order?
Yes, ma'am. So prima facie, 3 things are there which have to be considered while granting or dismissing the temporary injunction application. So first is a prima facie case. There has to be a prima facie case which actually suggests that there has been a violation of right, or a defense is particularly present there. Secondly, there should be irreparable injury which is caused. So if I am granting the injunction to the plaintiff, so whether it is causing an irreparable injury to the defendant, or whether if I am dismissing it, then plaintiff would be suffering more. And thirdly, balance of inconvenience. So on whose side balance of inconvenience lies? Who will be the person who will be suffering the most if I'm dismissing the temporary injunction application? So based on these 3 pillars, one has to decide whether the temporary injunction has to be granted or not.
Okay. कोई केस लो कहाँ मेंशन है? ये तो बेयर एक्ट में है आपके?
No, ma'am, it's not mentioned in the Bear Act.
तो definitely there was a case law?
Yes, ma'am.
अच्छा कोई बात नहीं, अच्छा ठीक है कोई बात नहीं। स्पेसिफिक रिलीफ एक्ट का आपने अभी नाम लिया, ठीक? स्पेसिफिक रिलीफ एक्ट, इसका इस एक्ट का नेम ही अपने आप में बहुत डिफरेंट है। व्हाट्स द मीनिंग ऑफ स्पेसिफिक रिलीफ?
Yes, ma'am. So, ma'am, specific relief basically means that instead of giving compensation to the plaintiff to restore its position, we mandatorily want that person to perform the particular act that he promised. So we are offering him that particular specific relief which he was promised earlier, erstwhile, so that he can be restored to his original position had that particular promise been performed. So instead of giving compensation, etc., we ask the defendant to perform that particular act.
वेरी गुड, वेरी गुड। अच्छा बताइए, कितने तरह के यहाँ पर आपको स्पेसिफिक रिलीफ्स दिए गए हैं इस एक्ट में?
Ma'am, so there are various kinds of specific relief. For example, in Section 6, for restoring the possession we have. Then we have a perpetual injunction we have in order in Section 41 and 39. Then we have a mandatory injunction. And ma'am, apart from this also, we can claim compensation in addition to the specific relief. It is given under Section 21. And in cases of partition, etc., a person, apart from claiming specific relief, also he can request the court to grant partition and things of this sort. Then declaratory remedy is also given under Section 34. So
34 में जो declaratory remedy है वो कैसी हैं? उनका nature क्या है? In rem or personam?
Ma'am, it binds the parties to the suit with regard to a particular right which is claimed on a legal right which is claimed by the parties, or a legal right to the property which is claimed. So it binds the parties to the suit. It is not in rem. And if you have any further remedy, then you need not invoke the jurisdiction of the court for this.
अच्छा, declaratory इसमें आप किस तरह के declaration claim कर सकते हैं?
Yes, ma'am. So particularly declaration can be with respect to legal right. Now this legal right can also be with respect to the legitimacy of the child. This has been held in a Supreme Court landmark judgment. I'm unable to recall the name of it. And secondly, it also pertains to a right with respect to the property. So if there's a property dispute and one wants to say that I have the right to this property, then he can very well go to the court to have declaratory remedy. But he should not have any further remedy available. That is the proviso.
ओके ओके, ठीक है. अच्छा, ये बताइए, अभी आपने बताया लेजिटिमेसी से रिलेटेड भी है यहाँ पर.
Yes.
तो कैन यू कनेक्ट सेक्शन 34 of a specific relief act with the provision of Indian Evidence Act?
Yes, ma'am. Ma'am, so Section 112 of the Indian Evidence Act provides for presumption as to legitimacy. It says that if while the mother and the father, they are married, or within 280 days of the dissolution, mother being unmarried, if a child is born, then there is a conclusive presumption that the child is a legitimate child. And unless and until you provide and you give a proof that there was no access available, so till that particular time, this presumption operates. This is given under Section 112.
So this is conclusive presumption.
Yes, ma'am.
What is the status of DNA test regarding the conclusive presumption? क्या है? Whether the conclusive presumption may be rebutted by DNA test or not?
Yes, ma'am. So I believe that in the case of Gautam Kundu, this particular proposition was pronounced by the Supreme Court. It was said that no mother can be forced to undergo or undergo any scientific techniques so as to ascertain the legitimacy of the child. However, if she opposes, then an adverse inference can be drawn. So in case wherein we have no other opposing evidence available, then very well we can go with the medical evidence. That is the general principle of Evidence Act. So wherein there are no contradicting facts available, and if the DNA test is done and it claims, it comes out with the fact that the person is legitimate or a legitimate child, then very well the court can consider that fact. However, it is not very conclusive. So solely based on this fact, no judgment can be given.
ये मुझे बताइए, जो कॉन्क्लूसिव प्रेजम्पशन रेज की जाती है 112 की, इस प्रेजम्पशन को रेज करने से पहले क्या कोर्ट एक रीजनेबल अपॉर्चुनिटी प्रोवाइड नहीं करती ऑपोजिट पार्टी को? फॉर एग्जांपल, द ऑपोजिट पार्टी इज द हस्बैंड एंड ही इज डिनाइंग दैट ही इज नॉट माय लेजिटिमेट सन, एंड एट दैट टाइम इफ द चाइल्ड इज बोर्न ड्यूरिंग द कंटिन्यूएंस ऑफ मैरिज, या आप कह सकते हो कि बहुत ही कम टाइम में बच्चा बोर्न हो गया है, तो क्या कोर्ट को 112 में कंक्लूसिव प्रेजम्पशन रेज कर लेना चाहिए कि दैट सन इज द लेजिटिमेट सन ऑफ द हस्बैंड, और कोर्ट को हस्बैंड को नॉन एक्सेस प्रूफ करने का एक रीजनेबल अपॉर्चुनिटी देना चाहिए? क्या लगता है आपको?
Yes, ma'am. So, ma'am, basically following the principles of natural justice, of course, opportunity has to be given, and this is a conclusive presumption. However, a rebuttal can be given on the basis of no access. So, this is the beauty of this section, that even though it is a conclusive presumption section, but it provides a rebuttal opportunity to the husband. So, very well, the opportunity has to be given to him to prove no access, and if it is proved, then of course, conclusive.
My question is that the opportunity is given before raising the conclusive presumption or after raising the conclusive presumption?
Ma'am, I believe it is before raising the conclusive presumption.
Yeah, so it's not rebuttal. Okay, conclusive presumption can never be rebutted. Yes, before raising the conclusive presumption, the opportunity is given to the opposite party husband. Okay, very good. बहुत अच्छा है शिप्रा, योर स्पीकिंग स्किल इज टू गुड, योर नॉलेज इज टू गुड, योर कॉन्फिडेंस इज टू गुड, बहुत अच्छा है, वेरी गुड। बस मैंने एक बात आपको बताई है, थोड़ा सा गुजराती लैंग्वेज पे काम करिएगा,